Greetings, greetings. What's good, YouTube? What's good? Hope everybody is good. Having a wonderful weekend, a week beginning, our strength beginning. I don't even want to use the word weak. We're all strong. Yeah, so I want to say thank you to all my subscribers for tuning in. Um, Thank you very much. And thank you enough, but grateful. Um, Today I want to just do a little bit on the crown and what mortmain means. Okay, so I'm gonna start with mortmain. Okay, let's get to it. Now, mortmain is the perpetual inalienable ownership of real estate by a corporation or legal institution. The term is usually used in the context of its prohibition. Historically, the landowner usually would be the religious office of the church. Today, insofar as mortmain prohibitions against perpetual ownership still exist, it refers most often to modern companies and charitable trusts. The term mortmain is derived from medieval Latin mortum manus, literally dead hand, to Old French mortmain, modern French morteur. So, mort, the term mort, the phrase mort, or the prefix mort, literally means dead. Okay, so when you're paying a mortgage, it's mortgage. Okay, really, they just silence the T, so it's a dead pledge. Okay, and that's what this all connects to. So your mortmain entity would be your juristic person that you use to commerce through this fictitious world. Okay, this fictitious fiscal system, so to speak. All right, so let's get to it. History. During the Middle Ages in countries such as England, the church acquired a substantial amount of real estate. So pay attention, the church, okay, and England, right? As you know, from that side of the world, they took their religion to this side of the world and imposed it upon us over here. And I'm saying their ideas, their Catholicism, that's what they took over here. So they took the church, right? So the church acquired substantial amount of real estate. As the church and religious orders were each recognized as a legal person. So your churches are nothing but legal persons, people. Okay, just like your fictitious entity that you use to commerce. Okay, separate from the office holder who administered the church land, such as the abbot or the bishop. Now we all know who the bishop is for the Vatican, right? That's the Pope, right? The highest bishop. So he's the office holder of the legal person. Okay, so this is what a mortmain is. The Vatican is a mortmain. Okay, this is how they control the land of the people. Okay, they use the trust. Okay, sorry, the land would not escheat on death of the holder or pass by inheritance, as the church and with the religious orders. Sorry, man. Sorry. Yeah, sorry about that. My throat got real dry. Sorry. Yeah, where was I? Okay, escheat on the death of the holder or passed by inheritance, as the church and the religious orders would not die. So, people, that's what you call a irrevocable trust, and that was created by the Grand Tour. Okay, that's what you call an irrevocable trust. Okay, the land was held in perpetuity. This was in contrast with in this was in contrast to feudal practice, in which the nobility would hold land granted by the king in return for service, especially service in war. No, this is what the papal created. Okay. I forgot the first type of trust that was created by the Vatican. But yeah, this is what the papal was. That's why they decree that they would own all the lands, okay, on the planet. That's why they did. Okay. Over time, the church gained a large share of land in many feudal states. This was cause of increasing tension between the church and the crown. Now, pay attention, the crown, okay? The crown, as you know it, is the head of state for many of these Commonwealth states, okay? And they just put their tentacles um by way of contract. So the nexus is the contracts, okay? Whenever you contract with through the system, either way, use anything you apply for, a job, driver's license, all that stuff, it's connected through the crown to the crown, right? But nevertheless, it's like yin and yang because one side is Catholic and one side is the crown. But the Church of England and the Vatican, they're pretty much uh the same snake with two head. Okay, so don't get it twisted. In 1279 and again in 1290, statutes of mortmain were passed by King Edward I to impose limits on the church holding of property. Although limits on church power to hold land are also found in earlier statutes, including Magna Carta. Okay, so your Magna Carta, okay, was all about limiting the church and the power over the people's land holding, okay? In 1215, and the provisions of Westminster, you could look into this document as well, provisions of Westminster. The broad effect of these provisions was that the authorization of the crown was needed before the land could vest perpetually in a corporation. Now, remember when I showed you the Crown Vesting Act? Remember when I showed you that document, the Crown Vesting Act? When I told you that Jamaica, all these colonies are nothing but crown trust that is set up to usurp the minerals on the land to benefit the crown and her heirs. Well, there you go. Okay. All right. So they talk about the vesting. Okay. As an example of the response of the institution, the Chartulary of Chester Abbey records that shortly after one of these statutes, vulgarly called Mortmain, 11 acres, 4.5 ha, I don't know if that's hectares or in Ash, Surrey, were held by Robert de Zaith with sufficient common pasture for his flocks and herds, while Geoffrey de Baxit and his brother William had 28 acres, 11 hectares, I guess. Although statutes prohibiting mortmain have been abolished in most countries today, right? So the statutes that prohibit the church from taking the land, they abolished them in most countries. So basically, the church is really controlling the land. That's what they're saying. And if it's not the church, it's the crown. It's one and the same. A similar legal principle still exists in some jurisdiction in the form of rule against perpetuities, right? Mortmain played an important part in legal history, and earlier case law often needs to be considered against this background. For example, the judicial decision of Thornton versus Hull held that a trust for publishing the writings of a Jonas Southcott was charitable, being for the advancement of religion. So you remember they do everything in the name of religion, in the name of Christ, right? Okay, they slaughter our people in the name of Christ, okay, of their God. This decision is often held up as setting the bar extremely low in determining whether the charity is for the advancement of religion, but if one considers that at the time the statutes against mortmain were in force, that effect of the decision was that the trust was void, rather than imbuing it with special privileges in relation to taxation. It puts a very different spin on the ratio decidendi. Decidendi. So the origin of the term mortmain, you already break down the the etymology of the word, and the Islamic too. Okay, so they have something called a waqf in the Islamic culture. It's the equivalent to mortmain. So all these religions are nothing but statutory laws to govern the people. Okay, take their land. So I'm gonna go to the crown. So the crown is the state in all its aspect within the jurisprudence of the Commonwealth realms, and their subdivisions such as crown, dependency, provinces, or states. Legally ill-defined, the term has different meaning depending on context. It is used to designate the monarch in either the personal capacity as head of the Commonwealth, or as the king or queen of his or her realms. It can also refer to the rule of law. However, in common parlance, the crown refers to the function of government and civil service. A corporation's soul, okay, that's what a crown is. Pay attention. The crown is the legal embodiment of executive, legislative, and judicial governance in the monarchy of each country. These monarchies are united by the personal union of their monarchs. They are independent states. Okay, just like the United States, okay? The United States, each state is independent of each other, but they're in one union, okay? The United States is a union. The concept of the crown developed first in England as a separation of the literal crown and property of the kingdom from the person and personal property of the monarch. It spread through English and led to British colonization. See? See that? Colonization, right? And is now rooted in legal lexicon of the United Kingdom, its crown dependencies, and the other 15 independent realms. It is not to be confused with any physical crown, such as those of the British regalia. So I told you it's a trust. Okay? It's what they do is set up trusts to take your land, or our land. The term is also found in various expressions, such as crown land, right? Which some countries refer to as public land or state land, okay? As well as in some offices such as Minister of Crown, Crown Attorney, Crown Prosecutor, okay? So all your prosecutors that's prosecuting you, whenever they summons you to court, you always see the state off versus your fiction, your fictitious entity. Just bear in mind that it's the crown, okay? The crown entity that is prosecuting you, okay? This is why you have to be always in your proper standing in law or in law, okay? So you could step outside that realm and control it, okay? Because you're the one in charge, okay? The concept of the crown took form under the feudal system, okay? The feudal system, you all know what feudal means, right? Feudal means like you work and you can't own the land, okay? You only could farm it, like homestead it, okay? Though not used this way in all countries that had this system. In England, all rights and privileges were ultimately bestowed by the ruler. Land, for instance, was granted by the crown to lords in exchange for feudal services, and they, in turn, granted the land to lesser lords. Okay, so when your Bible talk about lords, just know you are the Lord, okay? You are the Lord of your realm, okay? One exception to this was common soakage, right? Owners of land held as soakage held its subject only to the crown. When such lands become ownerless, they are said to escheat. Okay, that's a real estate term. Okay, when you die or anything, there's no if there is no heirs, it's escheat back to the state. Okay, get return direct ownership to the